Thank you all for taking the time out of your busy schedules. Hopefully this morning will be informative, which I'm pretty confident it will be. We've got some great speakers for you and some really relevant information that we're hoping to get across to you all. We're going to put, if you've got any questions throughout the morning, please put them in the group chat. And then what we're going to do is come to those at the end of all the presentations, and then we'll address all the questions there. But equally, rest assured, we've got the video that's going to, well, it's being recorded at the moment, so the video link will be sent out as well, as will all the slides for the presentation, so that you have the details of the independent speakers if you need to make a sort of direct contact of those people from there. So to start off with then, we'll recap on what we're looking at. We're going to be going over employment law in parts 1 and 2. We're going to look at the HR perspective, how businesses can prepare, and then we're going to finish up with a compliance update so that you're going to be looking at what is preventing illegal working. Our guest speakers for the morning, we have Claire Holland, who's a partner for Anstey, 20 years plus experience there, and we've got Mike Thompson, who is equally, he's well experienced there with over 10 years experience as a legal exec with for Anstey as well. Hannah Bloomfield is our head of HR and corporate services, been with Smart Solutions for well into 9 years, I believe. CIPD qualified, and we'll be talking about our HR trends. And then we've got Ola, who is head of our compliance, and again, a wealth of experience there with 15 years plus. So without further ado, I'm going to hand over to Claire, who's going to start us off with employment law.
Thanks, Steve. And thanks everyone for coming today, and to Heat Recruitment for inviting us to come and talk about employment law changes this year. So just a quick intro. I know that Steve just said, but I'm an employment partner at Anstey. I do everything HR and employment law related. I specialise in advising private equity houses and portfolio companies, but also financial services businesses. I will just pass over to Mike to say a few words.
Yeah, hi everyone. My name's Mike Thompson. I am also an employment lawyer. I work with Claire quite closely, and while I do a general sort of employment law support for generally for businesses, but sometimes individuals, I do have a specialism in litigation and deal with quite a lot of employment tribunal claims.
Thanks, Mike. So as I'm sure you're all aware, there are quite a lot of employment law changes this year, and probably even more on the horizon, particularly if Labour come into power later this year. So this is really going to be a whistle-stop tour. But as Steve said, there will be time for questions at the end. And of course, if you've got anything that you want to talk about offline, our contact details are on the slide. So please do contact me or Mike after the webinar, and we'll be happy to chat anything through. So I'm going to pass over to Mike to talk about changes that have already happened this year.
Great, thanks, Claire. So firstly, holiday pay. I mean, we could do an entire webinar on this, but I don't want to bore you too much on it. So I think the main point to take away is that there's the return of rolled up holiday pay for casual, irregular and part-year workers. So employers are going to be able to pay rolled up holiday pay at the rate of 12.07%. Which used to be the case, was found to be not the right way to do it. Some employers have scrabbled around trying to do the right thing, and now the government has helpfully reversed all of that and said that 12.07% is fine. I think there's going to be some debate around what exactly an irregular worker, irregular hours worker or a part-year worker might be. I think there's also going to potentially be some complexity around where there's individual assignments, umbrella contracts, that sort of thing. So we're probably going to need to watch this space just in relation to that. Some other points on that is that there's now going to be an automatic right to carry over holiday for workers in certain situations. So, for example, if the employer hasn't recognised a right to paid annual leave because they've incorrectly labelled someone as self-employed when in fact they're either an employee or a worker, or maybe not warned them with enough time that they're going to lose their annual leave entitlement if it's not been taken by the end of the year, then there's also potential automatic right to carry over if they've been unable to take holiday, such as due to sickness or family leave, such as maternity leave. In addition to that, there's also some changes to how you calculate holiday pay. So things like commission payments, payments related to performance tasks, regular overtime, they all need to be included for the calculation of calculating holiday pay. I think a lot of employers have been doing that anyway, but it's now been put into legislation. One key point on the holiday on the rolled up holiday pay point is that the new rules apply for from the 1st of April 2024, but effectively from the start of your leave year. So if you do, as most employers seem to do, is January to December, these new rules won't actually come into play until the 1st of January 2025, even though they've technically going to be coming into force on the 1st of April. So that's one thing to think about. Moving on from holiday pay, the immigration health surcharge. So that's a fee that may need to be paid when making an immigration application. Payment of it allows visa holders to access the NHS and NHS services. The increases were pretty significant. So employers, if you factor that into, if you are covering those costs for your workers, for your visa holders, you'll need to factor that into your budgets. But if not, then it'd be good to let the individuals know that they do have a fair amount more to pay. And I will hand over to Claire to talk about the next slide.
Thanks, Mike. So there's quite a lot of change coming in April. So these are the things that you need to be really preparing for now. And most of them are family friendly changes that you need to be aware of. So the first one is paternity leave. So the changes there are quite straightforward in that the 2 weeks paternity leave will now be it will now be possible to take that in 2 separate 1-week blocks rather than just one block of 2 weeks. The notice requirement will be reduced from 15 weeks to 4 weeks, and there'll be a longer period in which paternity leave can be taken. So it will be 52 weeks after birth or placement for adoption purposes. So I think the action points from this is really just to be aware of those tighter time frames and also that longer period during which paternity leave can be taken, just to make sure that you're able to organise cover and make sure that you've got the systems and processes in place, and also update your policies as well. The next one is the extended period of special protection from redundancy. Now, this is already in place for people on maternity leave and other family-friendly leave. Whilst they are on leave, they get the priority right for suitable alternative employment if there is a redundancy situation. So that's the existing right. And that's now been extended to apply also during pregnancy and also for 18 months after the birth or adoption placement. There are lots of kind of technical bits around the 6th of April, which is the date it comes into force in terms of kind of when you're told someone's pregnant, when they're taking maternity leave, when the baby's born, shared parental leave. So you just need to be really aware of that. But we just haven't got time to cover that today. But and again, it's really just making sure that you've got the policies in place to reflect the changes and also processes to make sure that people are aware of this, obviously, when you've got a redundancy situation. The next change coming in on the 6th of April is carers leave. So this is a new statutory right to 1 week's unpaid leave per year for employees who are providing or arranging care for a dependent with a long-term care need. So that can be taken in half days or full days over 12 months. And there's no minimum service requirement to qualify for this. And with all these family-friendly rights, there's protection against dismissal and detriment. So if an employee is dismissed for exercising this right, then it would be automatically unfair. I think, again, it's just making sure that you either update the policies you've already got in place for time off or have a new policy to deal with this. To be honest, it's not a massively generous right. It's 1 week's unpaid leave. So it may be an opportunity from an ER perspective to do some really positive comms around it if you're looking to do it as paid leave or possibly even do a longer period. It would just be a good one to be able to kind of build on the basic statutory right that's there. On the next slide, looking at flexible working. So as I'm sure you're all aware, all employees have the right to request flexible working if they have 26 weeks or more service. It's for any reason now, not just for childcare. That changed quite a few years ago. And this is where you're looking at requests for kind of part-time working, changes to place of work, hours of work, job sharing, hybrid working, all that kind of good stuff. So from April, it will be a day one right. As I said previously, it was 26 weeks service. There's a new duty for employers to consult with an employee about their flexible working requests, which I expect people are already doing. But there were ACAS have published a draft code, and that will have more information about what that consultation looks like. I think for me, one of the big ones, apart from obviously the day one right, is that the period to respond is being reduced from 3 months to 2 months. And that includes any appeal process as well, which I think can sometimes be quite difficult to do. You can mutually agree to extend that, but you just need to be really clear and have a paper trail if you do extend that period, because there have been cases on that where employers have got that wrong. And also employees will be able to make 2 flexible working requests in a 12-month period rather than just 1. Again, it's a good job of covering this later, because you'll need to make sure you're updating your policies and procedures. And again, just being really conscious of that shorter time period, because that could put a bit of an administrative burden on employers, and just need to manage that. We've then got immigration. Again, this could be a webinar in itself. I think it's probably just worth saying that the government announced a 5-point plan to cut migration levels. There's quite a few things, one of them being the increase to the minimum salary. We do have a specialist immigration lawyer in our team, Gemma Robinson. So if anyone has got any specific questions around that, she's probably the best person to contact. And then just to mention the IR35 offset. So I'm sure you're all aware that I think it was 2021 changes to IR35 in the private sector came into play, which I think made employers have to look at their workforce planning. And the changes mainly were around the end user having to do a status determination statement on employment status or deemed employment status. And also if there was income tax or national insurance to be paid, the liability for that moved from the PSE to the fee payer. So those were the changes that are already in place, I'm sure you're already aware of, but it left a big hole because there was no offset mechanism. So if HMRC came along and said, actually, you've got this wrong, this person is a deemed employee, the contractor is a deemed employee, and therefore income tax and national insurance contributions are payable, there was no way to offset that against any corporation tax or income tax that the PSE already paid. So that is a hole that is going to be plugged from April, but I do think there is going to be some complexities around that in terms of how that will be applied, and we are still waiting for the regulations on that. So that's the spring. I will pass to Mike to talk about the summer.
Thanks, Claire. So firstly on what maybe is going to come into play in summer is that employers are now going to be responsible for ensuring that tips are paid fairly. So obviously that's going to, it's most likely going to impact the hospitality sector. The new obligations are going to require employers to fairly allocate qualifying tips to workers. What qualifying tips are, I think, is going to be clarified a bit later on. To make payment of the tips within 1 month of payment from the customer. And I think there's potentially an increased administrative burden around this, because there's going to be a requirement to have a written policy setting out how tips are dealt with, and also to maintain records up to 3 years. And I think it's going to be something that employers are going to want to think about, because the employees can request disclosure of those records, and then bring claims potentially for failure to provide that, or failure to adequately keep those records. So I suppose for businesses where tips are a regular thing, you'll need to have that new policy and procedure to ensure that you've got adequate measures in place for calculating tips, and making sure that you've got proper ways of recording that. Payroll teams are going to need to be trained on these new requirements, and you'll need to make sure that there's procedures in place for how those are paid. But I think most importantly, there is going to be a code of practice on how this should work in practice, and hopefully, fingers crossed, that will provide a lot more clarity, because frankly, the legislation, I have read it and it's pretty dry and quite complicated. Moving on to TUPE, speaking of dry and complicated, I see Claire there. She loves TUPE. The requirement to elect employee representatives has now been relaxed, or will be from July, meaning that employers can directly consult with employees where they're in the business. There's fewer than 50 employees, and where for a business of any size involved in a transfer of fewer than 10 employees. And then there's also been, moving on from TUPE, there's also been the draft code of practice on dismissal and re-engagement, also known as fire and rehire. It's a controversial practice. It seems to get a lot of attention in the media, but in mine and Claire's experience, we've definitely seen a notable downturn in the practice, whether that's because of the adverse publicity it's been receiving or not. I'm not sure. I don't know if Claire, you've got anything to add on that. But essentially, the code emphasises that fire and rehire should be a last resort, and that employers should engage and consult with employees and reps as early as possible. I suppose one of the key points on that is that a failure to follow the code could result in an uplift of up to 25% in any compensation awarded from an employment tribunal claim. So similar to sort of the same thing of failing to follow the ACAS code on grievances and disciplinaries, could be a substantial increase. I suppose that one of the really odd things about it is that there's going to be a requirement to consult with ACAS before taking any such steps. No idea what involvement ACAS are going to have or what guidance they're going to be providing. So I think that's going to be another watch this space and see if further information comes out in due course. So I will hand back over to Claire to talk about the next slide.
Thanks, Mike. Yeah, on the fire and rehire, I think that the question always really is are you actually going to go ahead and dismiss people if they don't agree to their change of terms and conditions? And I think we're seeing a lot more that employers kind of want to achieve the new T's and C's, but will equally, if they have to, if push comes to shove, red circle people. So I think there's certainly a move away from that. I think it's probably different where it's either the alternative would be redundancies if you can't change T's and C's. But anyway, so I'm looking at the autumn and winter, and I'm just conscious of time, so I'll be a little bit quick with this. The first to mention is the right to request a predictable work pattern, which is expected to come into force around September. So this is a new right for workers, which includes employees and agency workers who have contracts that have unpredictable terms. So that's hours, working days, length of engagement. And just to flag, that includes fixed term contracts of less than a year. That's seen to be an unpredictable contract. They can request a predictable work pattern. Workers will have to have 26 weeks service to be able to make such a request. But just given the nature of the right, they will only have to work once each month to qualify for that. Workers will be able to make 2 requests in a 12-month period, and if they do make a request, then employers have to deal with the request in a certain way. So it has to be reasonable, they have to give a decision within 1 month, there are prescriptive grounds which they can reject the request, and other kind of conditions and requirements around that. In terms of action points, I think it's probably a good plan to start looking at your workforce now to see what proportion of your workforce might be entitled to make this request. And just to flag with agency workers, they can make the requests to the agency, but also to the hirer, depending on the circumstances. So I think this could put quite an administrative burden on businesses. So really just having a think about how this could impact on your workforce and whether you need to be doing anything differently to prepare for this in terms of that kind of predictable working pattern. And then the other one, just to mention, which is due to come in October, is this new proactive duty to take reasonable steps to prevent sexual harassment. So just to flag, there is already a duty for employers to take all reasonable steps to prevent any harassment, but that's around liability, and it's a really high bar. This is more about, well, it's just about sexual harassment. It's not a freestanding claim, so it's where an employee brings a sexual harassment claim. If they win that claim, if they're successful, and the employer can't show that they took reasonable steps to prevent it, then it's around the impact is on compensation. So the employees can be awarded up to 25% more compensation to reflect that. So yeah, I think really it's just one, again, to be looking at your policies, thinking about training. I think the key thing with all of this is to really try to instill a diverse and inclusive culture, you know, a culture where people feel free to speak up, which is probably a much bigger piece than just updating your policies. And it's also just worth flagging that we work with lots of clients in the retail and consumer sector, and we've introduced our own accreditation system called the Retailers Against Harassment Certification Scheme. So do contact us if this is of interest to you. So Mike, cool. Just quickly, other changes. Very conscious of time. Sorry, Steve.
Sorry, I'll rattle through these because yeah, again, I'm conscious of time. So proposed to come in April 2025 is new legislation for parents whose babies spend time in neonatal care units. So that will be a day one right, and parents can take up to 12 weeks of leave for neonatal care. But interestingly, employees will need 26 weeks of service to qualify for neonatal care pay, which will be set at statutory rates. So we don't know what those are yet. Again, going back to sort of like the carers leave point that Claire mentioned earlier, it might just be a good ER piece really to think about on that. So we'll have to wait and see what the rates are. Employment tribunal fees. So those of you that will remember that there were fees in place from 2013, but they were found to be unlawful in 2017, which caused a massive headache for the government. They're now proposing to bring them back in at a far lower rate of £55. Personally, I'm not sure if that's going to make much of an impact on people bringing claims or not. It might deter people from bringing spurious claims. I'm not sure if it's going to prevent people on lower means from bringing legitimate claims. There are also going to be ways of getting remission from paying those fees as well. So we'll have to wait and see what happens. Although, just a flag, Labour government might scrap the idea and might keep it free. The government's expected to decrease the age and lower the qualifying earnings threshold for pensions automatic enrolment from 22 to 18, and also to lower the qualifying earnings threshold to the first pound earned. I'm not a pensions expert. We do have one in our team. So if you've got any questions about that, get in touch with us and we can put you in touch with her. And finally, from me is the government has plans to limit non-compete clauses to 3 months. Claire and I think that probably will happen. It's been looked at in lots of other countries, including the US. So there is a trend definitely for it. And then I'll hand over to Claire to talk about financial services.
I'm literally going to say one sentence, Steve, which is that there's lots going on in financial services around diversity inclusion. The FCA and PRA consultation closed in December. Non-financial misconduct is incredibly interesting. That's built into the consultation. They're looking at target setting, data reporting. Treasury Committee don't like that. If you want to talk about any more, let me know.
Great stuff. Thank you both. Thanks, Claire. Thanks, Mike. I'm now going to hand over to Hannah, who's going to talk about HR trends.
Thank you, Steve, and thank you to Claire and Michael as well for that. It brings me on quite nicely into what I'm talking about with regards to HR policies and practices. So in terms of what's next, so now we know what the legislation is, how do we then build and understand that in our own organisations? So the first thing we need to obviously do is read and understand the legislation. I suppose the key thing is understanding it. So how do we translate that new piece of legislation into our business? So make sure you not only understand the legislation, but also how it impacts. Maybe it only impacts certain roles. For example, certain people, carers leave, for example, is a really good point. We then need to update and inform the board whether there are any significant changes to financials, process, or people within the organisation as well. We then need to either create or update. So sometimes we won't need a new policy for every new piece of legislation. It may just be an extra sentence in a policy we already have. But then again, it may be a big change, so it may have its own policy in its own right. We then need to obviously launch the policy to the business, but also not just launch that policy, not just put it on the intranet or in the handbook, but also integrate that policy with maybe staff training, manager toolkits, and staff awareness. It really depends on the change of legislation. And then last but not least, to review. So annually or biannually, keep it relevant and up to date. Obviously, if there are changes throughout the year, then change it as and when. But it is really important from a review perspective to make sure that if it mentions any roles in the business or things like that, that it is all up to date. Okay, so I'll talk a little bit about a policy that we introduced in the group in 2022 into 2023. So we looked at emerging case law on the menopause and how this kind of fitted into the Equality Act at the time and what employers were doing to ensure inclusivity. So firstly, we looked at our current D&I policies. What have we got in-house now? What policies could fit into menopause? Does it need its own policy? So questions about kind of considering where that sits and what that looks like. We then identified any policies that may be relevant to the menopause policy, so sickness and absence, for example, and then analysed our own demographics, so looked internally, who would this affect? And actually in the group, our demographics showed that it wasn't only employees that could be potentially affected by the menopause, but also new and emerging managers that may not be educated or equipped to do so. So when we were integrating this policy, that was a key consideration for us. So not only how do we help people that may be affected, but also how do we train people to also help them as well? We then explored training options. So how is this going to be trained across the group? We are in 68 locations across the UK. So is it face-to-face classroom training? Is it e-learning? So we considered our own organisation and how it was best to train and really kind of get to those people to understand this new policy. And then before we wrote the policy, we proposed it to senior management. So what was the aim of the policy? What impact would this have? And then any kind of financial or cost considerations in terms of training and that sort of thing. Thanks, Steve. If you could just, thank you. So in terms of creating our policy then, we used this kind of diagram as a building block really with all policies that we're creating. So this can be sort of a universal tool in terms of getting the basics of a policy right. So first we looked at kind of the definition. So what was the definition of menopause? What relevant law does it is kind of considered when looking at that? Who is responsible for updating the policy? Who is responsible for training the policy? And then what available support we're going to offer to staff. So whether this be training, signposting, toolkit. So what in the company are we doing? And then lastly, points of contact. So if they need to know more about it, who do they need to contact within the organisation, but also what charities are we working with outside of the organisation to help with this issue? I wouldn't be HR here if I didn't say about the ACAS Code of Practice. If there is an ACAS Code of Practice on the relevant legislation and or case law, always look at that to make sure that your policy mirrors that as well, because that's really handy. So when it came to launching the policy, it included a manager's guidance for colleague discussions, a confidential colleague discussion record, and then employee advice on how to talk to your GP about the menopause. So we sort of covered it from all bases. We felt that this covered all grounds from an employee, employer, and manager perspective. We launched it on World Menopause Day in October, and that is when we look to review it as well every year. So it kind of brings it back to that awareness day every time that we review the policy. And then in terms of training, to ensure integration and understanding, we made sure that it was a e-learning training, so it could reach everyone in the organisation, which is now in our annual refresher training record. So employees need to complete this every year. It's not just kind of a tick box training exercise. Okay, so what is on our agenda for 2024? So March is a really busy month for us, obviously, with all of the changes happening in April this year. And as Michael and Claire have talked about, the increased employer duty to prevent sexual harassment, this is now one of our priorities on our HR agenda. So the legislation confirms that it's not enough to just have a tick box policy. It asks people and employers to take all reasonable steps. It is vague in the HR world, but from our perspective, we are updating our policy, but not only doing that, we are looking at staff training and awareness. We already train bullying and harassment on day one of our corporate induction, to set the tone that bullying and harassment is not condoned within the group. However, we are now looking at a plan over the next 6 months to train all existing members of staff in this, and it is face-to-face classroom training for 2 hours. So it isn't just a tick box exercise, if you like. And then again, manager responsibility. So training, workshops, making sure that our stakeholders and our board are aware of this duty as well. So from the top down, and like Claire has already said, you know, it is about making sure that this is a culture piece rather than just a policy piece. And that's what I would advise everyone in terms of when looking at new legislation. How do we, yes, update our policies? How do we train our staff? But also, how does this become part of our culture to make sure that this is within and kind of ingrained within our organisation? And that is it from me. If I did talk about anything today that you would like more information on, or even just a chat about your HR policies and practices, my details are here. But yeah, thank you very much. Thanks, Steve.
Great stuff. No, thank you, Hannah. Thank you. Okay, we're now going to hand over to Ola, who's going to talk on compliance. You're on mute there, Ola.
Yes, I am. Sorry.
There we go. There we go.
Thank you. Good morning and welcome to the compliance section of our webinar. In this section, we'll concentrate on the importance of preventing illegal working. The world of immigration is constantly evolving and making increasingly difficult for employers to understand what their responsibilities are in terms of right to work checks. With global mobility and remote working firmly part of our everyday life, it is crucial that businesses consider immigration and understand the answers to all of these questions. In this section, we'll cover the latest changes to the business immigration, more specifically the recent updates published on the 13th of February, the potential risks of our businesses for not complying with the legislation. We will then move on to what is required of UK employers to ensure that we comply with that legislation. And finally, what can we do to prevent illegal working in our businesses? Next slide, please, Steve. So the Home Office is picking up the pace on immigration compliance matters, and we have certainly seen that increased activity over the last couple of years. As part of this drive, the Home Office has announced the changes to the civil penalty fines regime, which from the 13th of February 2024 have tripled. The civil penalty fine for each employee found to be working without permission or in breach of the visa conditions will increase from £15,000 to a staggering £45,000 for your first breach. For any subsequent breaches, the fine triples from £20,000 to £60,000 a time for each employee. So basically, getting it wrong can be really expensive. And to be honest with you, immigration is a compliance obligation that cannot no longer be ignored. We'll have a next slide, please. Hiring illegal workers can have serious consequences for UK employers. Whilst the government is committed to maintaining a strong and fair immigration system, employers are expected to play their part in ensuring that legal and compliant work they have legal and compliant workforce. So today we'll discuss the potential risk that businesses may face if they don't comply with the legislation, and what can be done to avoid those risks. So we have already learned from my previous slide that employing illegal workers without the right to work in the UK comes with a chance of civil penalty for the employer if they're unaware of the situation. But if they are, it becomes a criminal offence. If considered a criminal offence, the employer risks both the fines as well as up to 5 years of imprisonment, business closure, and disqualification from holding positions of directorship in the future. So we have already established that the civil penalty for employing an illegal worker under the new legislation is set to triple to a huge 45,000 and then 60,000 respectively. So it's a massive increase of costs under the new laws, and it can be financially damaging to any business, especially the smaller entities with less resources. But as such, it's absolutely paramount for employers to stay on the right side of the law, especially in the light of the new changes. Hiring workers illegally can also severely damage an employer's reputation. This can lead to actual loss of business and loss of customers, the trust of the public as well. And reputation damage is not easily repaired, and it can have really, really long-lasting consequences for a company. And then perhaps the most basic step that so many employers fail on is to accurately check an employee's right to work. In order to defend against a civil penalty, an employer must have something which is called a statutory excuse. In other words, have you done everything in your power to properly vet your employees? To achieve this, businesses should conduct thorough checks on documentation of the prospective employees prior to employing them. And I must point out here that this is extremely important to remember, that if your new employee was introduced to you by a third party, i.e. recruitment agency, you must carry out the right to work checks yourselves and do not rely on the documents or checks provided to you by that third party. You will not have the statutory excuse in that case. Thank you. So as UK employers, we have certain legislative responsibilities and requirements that we must adhere to prevent illegal working. It is imperative that we have systems, policies, procedures, processes in place to ensure that we don't put our organisation at risk. Firstly, remember that employing a new member of staff, when employing them, you must conduct right to work checks prior to their employment. This is not just legislative requirement, but also prevent any potential future complications down the line. And all too often, one of those things that catches us out is having insufficient documents to prove their innocence. So ensure that all of your records are accurately and meticulously maintained, timed and dated, so to make sure that if any questions of compliance do arise, you always have that evidence to fall back on. Also, remember that visas can always expire. It is imperative to perform regular checks rather than just a simple one and done approach. Digital record keeping will allow you to perform this task with much greater ease. However, I'm very aware that more often now businesses invest in HR system, which allow you to sort of track and notify you of expiry dates. Whichever method works for you, just be aware that ignorance is no longer defense when it comes to law. Actually, never been, but it's no defense when it comes to law. So make sure that you have a strong foundation if there's if any sort of compliance issues occur. And then keep on top of the current legislation. It's an absolute must, and ensure that your HR personnel and hiring managers are well trained in immigration and employment law. Bear in mind that it is also possible that a fine can go to the individual that conducted the check and not necessarily just the employer. It is imperative that everyone concerned remain up to date with changes to legislation to avoid any unintentional violations. So what should you do to minimize the risks and establish your statutory excuse? Well, firstly, ensure that anyone with responsibility for carrying out the right to work checks in your company, and that will include your line managers, your in-house recruitment teams, talent acquisition teams, and not just HR, because I know lots of emphasis has been put on HR in this situation, but all of those people have to have regular and in-depth training. And the UK's right to work regime is not straightforward, and the penalties for getting it wrong are getting so high that, in my opinion, training and the right legal support, perhaps, it's definitely a worthwhile investment. Secondly, comply. If you already have an established onboarding process, review it. Ensure that the correct method of right to work checks are carried out. Should you be doing a manual check, an online check, or maybe seek assistance from an approved identification service provider, you must know which of those is available and applicable to you at the time of each right to work check. And finally, audit. Carry out regular file audits to ensure that you have correct type of proof of right to work for every one of your employees, existing and new ones, regardless of their nationality, and take prompt action where a proof is missing or expired. Formalized processes for document checking and monitoring your staff are key to make sure that you have the most up-to-date and accurate information to hand. Audit regularly, and you stand the best chance of keeping your business above board. And just to summarize, I hope you found this section of the webinar informative, and now you have better understanding of, one, why is it important to prevent illegal working and what risk it poses to your business, and two, how to protect your organization from those potential risks. Thank you for your time.
Thanks, Ola. Thank you very much. That's been very informative. In fact, it's been really good advice from all speakers this morning. I've just got one question in the Q&A, which I'll just fire out there, and that's for you, Claire. That's in regards to carers leave, has 1 week been defined so that it's 1 week's equivalent for someone who is part-time or who may work 2 days a week?
Yeah, with all of these, it's normally on a prorated basis, so it would normally be based on their normal working pattern. So it wouldn't be 1 week per se. It would normally be based on how that individual normally works, as with holiday and things like that. Whether it's specifically dealt with in legislation, I'd have to go back and double check. But I can do that and follow up with the person afterwards. But yeah, I think that's certainly the position as I understand it.
All great stuff. Yeah, thank you for that. Thanks. Details are on the screen for everybody. That's the sort of the end of the questions that we've got. I think there's a lot there to take in, a lot to make sure that people are checking fully to be compliant. I think the election is going to have a big part to play on some of this legislation as well. But equally, thank you everyone for turning up. Thank you for being on the call this morning. We wish you all the best for the rest of the day.